Welcome, everybody, to our industry update this month. I'm Jill Cox with Chicago Title. We're thankful that you have chosen to spend an hour or so of your time with us this afternoon. I'm really excited to have this repeat guest with us today, Jerie Schwab. Jerry's one of the co-founders and people running Association Online, which many brokers in Colorado, you're familiar with their incredible company. I've known Jerie for a lot of years, and she runs a great company. But more importantly, she's a wonderful servant leader, and she wakes up every day with a passion to serve real estate brokers and to help them with the world of HOAs, which is a very, very complex and challenging world, as we all know, as we get to deal with them. So she's a wonderful advocate for all of you and for us as title companies. And we're so thankful, Jerie, for your time today. And you always have such great words of wisdom. Jerie and I were talking a month or two ago about Jerry's getting phone calls once or twice a month about lawsuits that are taking place between buyers and sellers, post closing with regards to associations. And then Association Online is taking measures to try to cover real estate brokers and prevent that from happening to
Yeah.
begin with. So we're going to jump into that. And then after that, we're also going to talk about Association Online's Home Expert Program, or HOA Expert Program, which I've been encouraging all my clients to sign up for because it's just a really different way of handling association documents. It's so much more proactive and smooth. And so we're going to look forward to hearing more about that as well. So with that, I'll turn it over to you, Jerie. And thanks again for your time today.
Thanks so much for having me, Jill. It's always fun to talk about HOAs. I know the audience may think that's funny, but we do love solving the problems that homeowners and realtors and lenders and title companies deal with HOAs. Our company started actually as an HOA management company, and my husband started it 21 years ago. It's amazing to me we've been in business that long. We shifted over to software and solutions in about 2008-9, and he still says the hardest job he's ever done is managing HOAs. So it's difficult for everyone, I want you to know. But what we're seeing so different in our market right now is the incidence of lawsuits regarding HOA information and disclosures. And as we've seen that escalate, we're putting some steps in place and some knowledge systems in place for agents to really cover that risk, because really, the seller is the party that's initially at risk for disclosure information. And then if the real estate agent has helped them or knows of information that they maybe haven't disclosed, they're being pulled into lawsuits as well. So I want to kind of explain the background on this. So in Colorado, we have a very extensive document disclosure package. We believe that's good. We think more information is helpful for everyone in the transaction, but it makes things a little bit complicated too. So there are 24 items that the seller is responsible to provide the buyer in the real estate contract. We step in, we do all the back office for many transactions. And when we do that, we guarantee the work that we do. So we're working to make sure that all 24 items that are required to be disclosed are disclosed. And I want you to know that 85% of the time when we go to a homeowner portal or we go to Condo Search, just the software that the manager uses to deliver HOA documents, 85% of the time, the document package is not complete when we first touch it. So there's the first level of risk for the seller and the agent, is to beware if you're just relying on what the HOA is disclosing, it may not be right. Like I'm saying, 85% of the time when we see it, it's not correct. And the liability is not on the HOA for that. The liability is on the seller or whoever the party is that's putting the document packages together. So that's the first level of risk. And we've dealt with that. It was 2019 when the disclosure package changed. And so we've dealt with that for a long time. But there's a new level of risk that's been added lately as well. And that has to do with the financial condition of an HOA and whether special assessments are coming or in the works or known about whenever there's a real estate transaction. And so we have seen an escalation in these lawsuits so much over the last, 2.5 years or so, and especially in the last 12 months. So let me tell you what's happening. In the Colorado real estate contract, the contract has, I guess, a litigation life. I'm not an attorney, so please, I'm not trying to be that, but The life of the real estate contract is 4 years. So after the contract is signed, after the sale takes place, if a buyer or seller has an issue with the real estate contract, they can still bring it to legal action. And so what we're seeing happen is that after the sale takes place, months later, even 18 months, I'm dealing with one now that's 2 years after the sale date. Now there's a special assessment that the new homeowner is receiving. And their question is, should I have known about this special assessment? Should it have been disclosed to me in the document package? And that's when the attorneys get busy, we've even seen some of these lawsuits go to a jury trial, and very often the seller is losing. And if the real estate agent was involved in putting the document package together or had knowledge of what was happening in the HOA, then they're being included too. So basically, the liability becomes the old seller becomes liable for the special assessment if they should have disclosed it, and then the agent as well, and legal fees. So, what really confuses sellers is they feel like, gosh, we put the document package together and I had the 24 items that were required, and they think that they're good with that. But what they don't realize is that the HOA, the seller, if they're let me see. If the seller is aware of certain financial issues in the HOA, they also are required to disclose those. And the HOA is necessarily not required to disclose those. So a seller will feel like we've got the bases covered, not realizing their liability versus the HOA. So let me explain. For instance, in an HOA, if there's a financial situation such as a current or pending lawsuit, an insurance claim that's current or pending, significant repairs that are needed, or special assessments that are current and pending in the lawsuit, the HOA by Colorado law is not required to disclose those in the document package or the status letter. Now, a lot of times HOAs will discuss those, but they're not required to. But the caveat that our sellers don't understand is if they are aware of those things, they are required to disclose them. So, for instance, where we're seeing lawsuits, a scenario is that a homeowner received a letter from the HOA saying, hey, we've got an insurance claim and we don't think we've got enough funds to meet the deductible. And so there's a potential special assessment. And then this is a real story. And then about 60 days later, they sold the home. It took a year for all the insurance work to come about. And now there's a $20,000 special assessment. Well, in that case, the seller was responsible for that disclosure because they had received a letter from the HOA explaining that that situation was in place. But the HOA was not required to disclose it. So that's an example of the seller needing to be aware and the agent needing to be aware of the disclosure. I've even heard of recently a condo project where real estate agent sold multiple units in the same project, and that agent was aware of some financial issues that led to a special assessment, and the agent was held financially responsible because they weren't disclosed. I know. So it's very surprising. There's another facet of that, which people say, gosh, wouldn't it be mentioned in the meeting minutes? And the buyer would see the meeting minutes. Well, that's a really good point because a lot of times it is. But there are two issues with that. One is meeting minutes can be very delayed when they're released. Colorado law doesn't have any kind of deadline that says after a meeting, the minutes need to be released by any period of time. A lot of HOAs, they don't release meeting minutes until they're approved, which means they're approved at the next board meeting. So for instance, let's say they have two board meetings a year. They had one in November. They're going to not release the November board meeting minutes until May, until they have the next board meeting, and those meeting minutes get approved. And they remember to release them, okay? Because there's no deadline that says that they have to release them within a certain number of days. So a lot of times whenever we're updating document packages and we're making them compliant, if we see the meeting minutes are old, we will go to the HOA and ask, specifically asking for more information on the meeting minutes. And a lot of times they're happy to comply, and we will update the package for that. But I just want you to beware that they don't have a deadline that they have to follow, and a lot of times they just get missed. Let's see what else I was going to say on meeting minutes. Oh, this is an interesting nuance when it comes to meeting minutes. I've had some folks that have dealt with lawsuits telling me about this as well. So HOAs themselves they have found themselves liable for what they've disclosed in their meeting minutes. And so this is kind of a double-edged sword. So what has happened is attorneys have been recommending to some HOAs to not disclose potential special assessments or issues that might imply financial conditions or financial situations in the HOA. And let me tell you why. Here's an example. There was an HOA who felt like they might be running into a special assessment. They disclosed that in their closing package. In fact, they were proactive about it and did that. And there was a homeowner that was selling their home, and their home was discounted in the sales price for the potential of an upcoming special assessment. And in fact, after 12 months of working on the issue, the HOA was able to remedy the problem without a special assessment. And then the seller sued the HOA for disclosing a potential special assessment that never occurred. So now you've got tension on both sides of that equation that's really creating a problem. So we love to get all the meeting minutes that we can, and we hope that the HOA discloses things there, but you can't rely on that. We just can't rely on that level of information, and that's where we go back to really at the bottom line is the seller is responsible for what they know.
Gosh, that's a
So,
fascinating story. Yeah, like you
isn't that
said, a
crazy?
double-edged sword. Yeah.
We have, in an effort, as we have watched these lawsuits escalate and see where the issues are coming from and so forth, we have added a safeguard to the process that we already follow for agents that are in our program. And we put together the document packages, we guarantee compliance, and we deliver those and keep them archived for any legal action that could occur. And we've taken an extra step in that. So when agents are using our program, we've added a little question list to what is asked of the seller whenever the document package is put together. And we're calling it a critical disclosure and account review checklist. So the idea is we want to prompt a seller to be thinking about these are the important things that I may not realize are important, and I need to speak to my agent about it. So, for instance, we're asking, have you received any notices or been made aware of any current or pending lawsuits within your HOA? And they have the ability to answer yes, no, or unsure because they may be unsure. Same with insurance claims, significant repairs, or just special assessments. Are you aware of any special assessments? But the idea is getting the seller thinking about what their liability is. And then after they answer this, we're delivering it to the agent so they're aware too, and they know what kind of conversations to have to make sure the disclosures are covered well.
That's super important. Can you maybe kind of dive into Jerry specifically, got it where that questionnaire lives with your
Yeah.
program? And then I think that would also be a great segue if you don't mind talking about the SAA.
Exactly. So our company uses something called the SAA, the Sellers Association Authorization Agreement. And we actually pioneered that back in 2019. And I don't know if you all remember, you were in the market in 2019, but that's when the real estate contract changed from about 10 disclosure items to 24. So a lot deeper and broader disclosure package was required. And we started working on those disclosure packages in an effort to save the sellers money. At the same time that the disclosure items increased, the cost of getting those items was increasing significantly as well. And now even I'm doing 2025 a data review, and we're seeing the document package. The highest so far I've seen in my analysis is $850 to get a CIC document package. So the pain is real when it comes to the cost. And so we started looking into how do we save sellers money? And we realized, oh my gosh, there's a second law in Colorado that allows a homeowner to receive HOA information for no charge. Not all that's needed in a transaction, but most of it. And so we created something called the Sellers Association Authorization Agreement. And basically, it's just an authorization where the homeowner says, I want someone to help me get the 24 document disclosure items that I need, but I want them to be able to do it under my right to receive information for no charge. And so we started doing that in 2019 and the Real Estate Commission adopted it. So all agents, you have it in your document package and you can use it too. So the seller signs it, it gives them authorization to get help to put their document package together, but under the law that says that they get HOA information for free. And so we use that in every real estate transaction that we can practically so that we can save the hundreds of dollars that are required for the documents. And we are using that form. We have it available for our agents electronically in a link and on a PDF with a wet signature and that kind of thing. But what we've done is at the end of that SAA agreement, we've added an extra list of questions where we're prompting them in that way that I just described to say, hey, do you know of any of these issues in your HOA? So we're just attaching it to something they already fill out so that it's easy and convenient and um, it just helps with the communication. It's that communication piece that can get missed or confused so easily.
Absolutely. That's great.
Yeah.
Um, Guys, if you have any questions as we go along, feel free to drop those in chat and I'll keep an eye on that. Um, And with that, Jerry, do you want to maybe kind of roll into association documents delivery?
Sure.
And okay, kind of like I said, we're really encouraging brokers to take a look at this kind of different practice and method of handling association documents because we all know custom practice in Colorado has been to wait until you're under contract,
Yeah.
then start that process of getting the SAA form, starting the process of, engaging
Yeah.
Association Online, and but we've got a deadline quickly approaching. So Jerry, tell them about the HOA Expert Program and how we can do that in a much more proactive way.
Right, exactly. We've had so many asks and needs identified by agents to us that they need better information early in the real estate transaction. And there are several reasons for that. One is simply the cost, like I just described, of HOA information in total. When we wait until the contract date to start gathering all of that information, it's very costly for one. And the timeline is very short. And the risk that we're running today is we're seeing a lot of real estate contracts. Well, 5 years ago, when the market was different, we would see an HOA property transaction. When it was listed, it would close on the first contract about 93% of the time, and it closed on the first listing about 98% of the time. So we have seen a change in the market with the price of HOA information increasing and that sales cycle expanding to a much longer process, meaning about 15% of the time we're seeing a property pulled off the market and a wait period before it's put back on the market. So a very slow sales cycle and about a 40% incidence of needing multiple contracts to sell. And why that is an issue is that there are those milestones where monies have to be spent. And what we're trying to help agents with is to shorten that sales cycle as much as possible and to save money as much as possible. So what we want to do is get information in the agent's hand and in potential buyers' hands very early in the process. So what we recommend is putting the document package, the CIC document package together at the listing. And we're doing that. So pulling it out of the contract cycle and bringing it all the way to the listing level. And what that does is the seller and the agent, first of all, right away at the listing, they understand all about the HOA. What we're including in some of those disclosures are more than the 24 items or the 23 items for the document disclosure. But we're also including things like 5 or 6 just basic warrantability measures. We're disclosing what is it going to cost to close. Working capital is a really important financial number that's becoming more and more critical in a real estate transaction today. So working capital initially in a real estate transaction was simply seed money. I would move into a brand new home and I would add an extra 6 months dues or something to my closing costs so that I could seed the bank account in the new home. We're seeing a trend in Colorado and other states too, where they're using working capital, not for that, but to fund underfunded reserves. And so what's happening is those numbers, in fact, as I'm working on 2025 numbers, I've seen at least one neighborhood where the working capital investment is over $50,000. So when a homeowner is selling their home or a buyer is buying, there can be these fees that are added that are unexpected in the real estate transaction. The risk in that you can imagine. First of all, when that information is disclosed for the first time when you have a contract, that's after you've negotiated the contract. We have buyer's agents that are wise and maybe have good information, and they're negotiating that the seller pay working capital, for instance, if the seller's not aware of the high cost there. And also, we have agents that say, gosh, if I'd known the working capital was $20,000 or something like that, I might have also known that this is going to be a difficult home to sell, and maybe I would have thought differently about my listing. So the point is, all of that information and all of that knowledge is important to know really early on. So in our agent program, we're putting the document package together along with that critical information early in the process. We can even provide you as agents the warrantability, some basic warrantability information, and the closing costs and the working capital costs in a really clean, professional report for you to view before you take your listing appointment and for you to take with you on your listing appointment. The point is, we want you to be very knowledgeable when you're sitting in front of a client, and we also want you to have the tools, the decision-making tools that you need to decide if you even want to take the listing. So the idea is pull all that information forward, get you good, accurate information, save you the upfront fees that come with a standard CIC package that we talked about. We will update the data that we're going to provide you early in the transaction for free through the life of your listing. The whole point is let's just pull it up early in the process so that you're clearly aware of what's happening. You can market the home well. But another piece of what we provide is a really good report that you can add to the MLS that tells a buyer some really strong information about warrantability, what are the amenities in the HOA, what are the costs, and also what are the living restrictions. So they can have access to a report that tells them how many dogs, what are the pet policies in this neighborhood, what do I do with my commercial vehicle, what are the home business rules. The idea is if we can summarize that information in a clear, concise, professional way, we want to let buyers know about the HOA and the decision points that are important to them before they write the contract. The idea is let's match a good buyer with the property early that matches their loan needs or has a high likelihood of doing that and matches their living needs so that when you get to the contract and you're trying to get to the closing table, you don't have delays or just fallen files because they learn about the HOA or they learn something that causes them to say no to the transaction. I can't hear you, Jill.
Oh, sorry about
Oh, there we
that.
go.
Okay. Are you ready to jump into some Q&A?
Yeah, I'd love that.
Okay. All right. So Natalie had a question about the seller, and I have heard about this being in practice at some point. The seller providing the buyer access to their account information, providing them the link and
Um,
login credentials. I not to jump in ahead of Jerie because she knows way more about this than me, but first thing that comes to mind is that the issue of what Jerie was talking about earlier, that 85% of the time, all the documents aren't provided
right.
in the portal. So, whether or not it's legal, I'll let Jerie jump into that. But I think sounds like there's probably some big risks with that as the solution.
Yeah, you're exactly right. For one thing, that being certain that the disclosure is complete and compliant is a real issue. But you hit on the other one too, and that is it's not lawful to hand over a password and allow someone else to just log in and get information. And so there are two areas where we're seeing issues with that. That's why we always use the SAA. We will never log into a portal without knowing we have written authority from the homeowner to do that. That covers us legally there. But there's another issue as well, just in general. It's not lawful for me to log into someone's portal without the software company or the company that owns that software knowing what I'm doing and allowing it to. And so we are covering that base as well. Every HOA that we deal with, we let them know we're using an SAA and what is the practice that you want us to follow when we do that. So we make sure that we've got their authorization and we have the written authorization from the homeowner as well, and we keep all of that archived in case there are any issues. And I'll tell you what, we have had people raise issue with that before, and we've got the archive of the trail of how we followed that protocol really carefully. So I would warn about that. And it reminds me of another risk that we've seen in the market, and that is the reuse of documents. This used to happen a lot in Colorado and around the United States, where people would just keep kind of file cabinets of even virtual file cabinets of files and then just reuse them. There are a couple issues with that. One is in our company, we guarantee compliance of document packages and we do not reuse them because they're not fresh anymore. And we want to make sure that the documents are fresh. But there are lawsuits over companies that have purchased, for instance, CondoCerts has a lawsuit that's been going on for years with CoreLogic, where CoreLogic purchased document packages for one property and then reused them for other properties, and that's unlawful. It looks like it's holding up in the courts, at least over the last 6 or 7 years it has, where the reuse of documents has really been challenged, and it's been challenged in court. So we would warn you, don't reuse documents. Don't log in without real clear authorization, but you have the tools to do that. You have that SAA in your own document set. And if you as an agent want to do that, you can have the seller sign that over to you as authorization to get the documents. And of course, we're in that business, and so we're happy to do it as well.
This is a good question. Stephanie is wondering, can you please address how you handle voluntary HOAs?
That's good. That's a great question. Um, we will when someone's asking, maybe they give us a property address and they want to know if there are HOAs on it and what the disclosures are that are required. We'll take a look and we'll let you know, is it a voluntary or a required HOA? And a lot of times our agents want to just see what is available in a voluntary HOA. Of course, there's nothing that's legally required to be disclosed there, but we'll pull together what we know and provide a little information report, just so that you're aware of maybe if there's any amenities they keep. Sometimes a voluntary only association, maybe they have a neighborhood picnic. They may have a landmark sign and flowers or something, and they just ask for donations to keep that up. But there's not a legal requirement to disclose anything there because typically there aren't legal documents. But we'll help you know what is behind that HOA so that you can be well informed and just look professional, answer all the questions professionally.
Sure. Okay, Anne is asking, what about HOA citation letters once you're under contract without a fine, say for a driveway that needs to be repaired but isn't due until 2027? Who is typically responsible?
Oh, that's a really good question. And you're touching on a point that I didn't make a minute ago. You know how I said we've added to the SAA a question, like a little question list, a tickler, basically, to look for legal liability. But there are a couple other questions we ask as well that just help you with transaction best practices. And one of the questions we ask are you aware of any covenant violations that are outstanding on your home? Because you as an agent, you want to know that. Your seller may not be thinking about that, or they may think, oh, we can slide past this. But the reality is it can slow down a sale. If there's a violation and something that needs to be remedied, like that example that you just described, that could be an example of that. We had one where a homeowner replaced their roof with a color that wasn't approved by the HOA. And the way they settled that was that the HOA didn't require the homeowner replace the roof immediately, But they said by the time they sell, if they sell, they have to fix the covenant violation. Well, 5, 6 years passed, and the seller, I don't know if they forgot or thought maybe the HOA forgot. I'm not sure which, but they listed their home, had a contract, and then it came up. And of course, now you're 60 days or so to get a roof replaced before you can close. So the point is, we want to have that conversation or help you as agents have the conversation. Are there any covenant violations? The other question we've asked on that checklist is, are you delinquent on your HOA balance? Sometimes sellers maybe don't want to talk about that, but the reality is if they are, it's okay. Usually the HOA will be very willing to even pause late fees and things like that because they know there's a sale taking place, and they're probably excited. If they're not getting paid, they're supportive of the transaction taking place in the hope that they'll have a homeowner that's paying their dues. So again, we ask that question so that you as agents know how to have that conversation with the seller. And in the case of that specific covenant violation, where it sounds kind of reminds me of the roof a little bit, that they have to replace a driveway, but within so many months, that is definitely something that the seller would be responsible to disclose. The HOA may require, if the home changes hands, that they don't have that delay of time. I'm not sure if they would transfer that over to a new buyer, or they may require action be taken before the transaction closes. So again, it's just good to know that and speak with the HOA so that it can be taken care of without problems in the end.
Jerie, let's maybe jump into some questions. There are some questions about just the cost associated with ordering documents at time of listing, and then kind of what that process looks like. Do we order them with the SAA through the title company, or do we contact
Mm,
Association Online directly? So let's maybe kind of jump into some nuts and bolts of the
yeah.
program.
That sounds great. So, as a member of our program, what we want to do is pull everything early to the listing or even before. And so, when you join the program, I'm using the word join, it is a membership program. But there's no membership fee. So we ask that you make a commitment to be a part of our program, and your commitment is that you will use us to do your CIC document packages. So it's pretty simple. And the cost for using us is $65 for that CIC document package. And then we use the SAA every time we can, almost always we can, which means you save all the upfront fees from the HOA for the document package. So the total fee generally is $65 because generally we can work it out where there's no fee from the HOA. So you would pay the $65 up front, and then we would prepare the package. We deliver it in an electronic link, not a 400-page zip file, but broken out by here are the minutes and here are the financials and that kind of thing. We deliver it to you and your seller so that you all can take a look at it, and that link stays live for a couple of weeks. And then it goes dark because we don't want old information published. We're really careful about that. Then, whenever you have a contract and you're ready to move forward, need the information again, you ping us through our portal, or you can text us or email us and let us know that you've got a contract. We redo the document package and we deliver it to all the parties that need it. No fee. You pay that $65 up front, and that's it for the life of the listing. If that contract falls, 2 weeks later, you need another package, you need it delivered, we do it again and we archive. This is exactly the package that was delivered on this time and date to these parties each time that that's done. So that's part of our liability coverage that we cover. So I've mentioned a portal. The idea is you become a member of the program, and we have a portal and communication methods for you, a lot of different ways that you can reach out to us. And we will show you what those are and get your preferences on how do you want to reach us? Do you want to email us? Do you want to text us? But there is a portal where you can go and click a button and say, hey, I'm going on a listing and I want a listing report. I want to understand this HOA before I go. And you click a button and we move forward. We learn from you ahead of time as you join the program. We learn, how do you want to pay? Most of our agents want their sellers to pay for the CIC document package, that's $65. And if they want an additional report like the brief, a lot of times the agent pays for that and then collects at closing. So we work through, here are all our reports, and these are your options, and we learn how do you like to do business, and we show you the portal and so forth. And and we learn how you like to work. When you get to a contract and you're dealing with the title company, you always business as usual. You reach your title company the normal way, you always do. We will hear from the title company if we already do their status letters, and we will link that together and let them know when we get the status letter request from the title company, we will let them know that you're a member of the program, and we've got the CIC document package revamped and ready to go. So we bring the pieces of the transaction together. But we have the methods and the source for you to communicate with us, and we'll train you how to use that. There are other features that come with that portal that are no charge to you, so it'll be important that you know how to use it. And that is, for instance, say you're on the buy side of the transaction and you get a document package from someone else. We have agents that say, I don't know if this is compliant. Would you review it? Yes, for no charge, we will do that. We'll look at that document package and review it for compliance. We'll deliver you a report that outlines what should be there and whether it meets compliance standards or not. If it does not meet compliance standards, we'll go to the seller and ask and tell the seller they're not meeting the compliance and that we would love to help them with that. Almost always, the seller will say, yes, I'd love to pay you the $65 to make sure my package is compliant. So we'll go to bat for you that way and get the package compliant. We also deliver a recap of the status letter for free for you so that it's just very professional, easy to read and understand. What are all the fees that we're paying, and who are they being paid to, and what are they for, and are there any covenant violations and that kind of thing? So we'll give you that report for free. We also we're basically your transaction coordinator when it comes to HOA information. So any questions you have about the HOA, you can submit them to us, and it's no charge for us to do that. We will do the research and help you answer those questions. For instance, we had an agent that had a listing in a flat in downtown Denver, and it was older, and the documents were older too, like in 1980s type documents. But this flat had an assigned parking space in a parking garage, and they had a rooftop patio. And her question was, are these two things deeded to my home, and are they exclusive to my homeowner? So at the listing, we started doing the research there. I'll tell you, in those 1980s documents, I mean, even the HOA manager didn't know. So that's part of the service we provided is we did the work and we did a write-up. And so she knew shortly after her listing how to negotiate those and what to expect in the closing, whether there was a deed to those or not. So that's the kind of work that we'll provide.
It's incredible. What a resource.
Yeah,
Jerie, so $65 for association documents up front. That's per HOA.
right.
Do you have any figures on what percentage of properties have multiple HOAs, or what's your experience here in Colorado?
Yeah, that's a really good question. We come in number two in the United States for this accolade. We can have up to 4 HOAs on a given home in Colorado. The only state I see that exceeds us is California with 5. So when we put the document package together, it's like a little insurance policy is the way a lot of our agents think about it. It is $65 for each package because we insure each one. And on average, I'd say on a weighted average, we've seen like 1.5 HOAs per home. So the likelihood of you having more than one HOA is high, is what I would say about that. But we'll find it for you. We'll figure it out. A lot of people then ask next, their add-on question to that is, what about metro districts? Metro districts, the disclosure requirements on those have changed. In August, that has changed, and we're looking into that. It used to be you don't need a document package, but the seller's responsible to provide the website URL. They still are required to do that, but there's some plain language disclosures and a couple of other new things that are required with a metro district. We will put a document package together for agents if you want us to on a metro district. They're required to have a publicly available website, which is nice. HOAs are not. and all the information is there, but it's sometimes really hard to sort through and it's really complex. And so sometimes agents or sellers will ask us to put the package together because it comes in that neat link with everything broken out. And so we will do that. And when we do it for a metro, we do it for the $65 as well.
Let's see. Okay, we had a question. Joni was asking, are there some HOAs that charge a fee for everything, including the documents, and it cannot be unbundled? I believe Westwind does this.
Yeah, you're exactly right. They do. They'll force a bundle, and we have some HOAs. And again, we have people bring things to us and we deal with lawmakers, but some folks have had issue with the forced bundle, is what we call it, where you're required to buy the documents as well as the status letter. And in some cases, they're even requiring you buy a lender questionnaire. That's a real issue because the seller doesn't need a lender questionnaire. And then the buyer does. And the buyer has to go buy a bundle that has the lender questionnaire and it has the documents in it that they don't need. So it's very difficult to navigate, but you're exactly right. Sometimes there's a forced bundle. So the nice thing though is we can escape the upfront fee and get you the information that brings transparency to the transaction early without incurring that bundle price. But if an HOA bundles and you get there to the contract point and you just need a status letter, well, right now the law doesn't say anything about them not bundling. And so what the law says today is they can't charge to make a profit. They can only charge the cost of what it takes them to provide information. So there's challenges there, but the point is you're right up against the contract date and the closing date, and you may have to buy a bundled package. But what we want to do is make sure we time the purchase of that where you eliminate rush fees, but you also aren't lower the risk as much as possible of having to buy that multiple times. Meaning we want to minimize the number of contracts that fall at that point in time. And that's where you end up having to buy it again and buy it again, and you're buying the bundle. But by us getting that information up early, where a buyer can really look at it and really understand what's going on in the HOA, that's the idea, is they make a good match early before you get to that time crunch and when all the money's being spent at the closing, real close to the closing table.
Okay, Jay's got a good question here. So the agent is receiving all the disclosures and that HOA information. Does that increase the agent's liability? The contract is specifying for the seller to provide the HOA docs to the buyer. So, but is that kind of looping the broker in if they're receiving all
Um,
that documentation?
well, what we would like to do is we put the information together and we're going to stand behind the disclosure package and we're going to deliver it to your seller and you and then all the other parties. We don't want you in the mix of delivering the information or being a part of assembling it. So that's where you would become liable for whether it's complete or not and compliant. And we want to take that piece on and carry the liability for that. So you just receiving it doesn't increase that risk there. The other issue, though, would be um, are there known financial issues in the HOA? And I think you're asking a good question. If you received the document package, do you know of any issues? I actually haven't had anyone ask me that exact question. But by talking with the seller and having them go through the checklist of what are you aware of, seller, I think that covers that base. The point is, okay, I'm thinking about this out loud. If you've got the document package in your hands, but it's also delivered, the exact same package is delivered to the potential buyer, they are informed of everything that you're informed of. And so I think that feels good to me. That seems great. The additional layer of risk could be that if you're aware of something else that's happening financially in the HOA that's not in the package and you don't disclose it, or your seller doesn't disclose it, either of you that know of that information could also be liable. But I feel like it passing through your hands, if somebody else has assembled it and sent it to all the parties and all the parties are looking at the same information, I don't feel like you're any more liable than anyone else. They received the same thing that you did.
That would be my non-legal feeling about that as
Exactly, my
well.
non-official legal feeling.
Yeah. Yep. Okay. Amy had a question here. She's a transaction coordinator, works with several brokers. She does try to send the SAA off to sellers, but runs into sellers being confused about the form and not really understanding what it is or how to fill it out. Do you have
Yeah.
any kind of pro tips on how to best explain that form to a seller so that they feel comfortable and confident filling it out?
That's a great question. We have kind of a leader sheet on ours that covers frequently asked questions that help them understand, why am I doing this and why am I filling it out? So if you'd like to see a copy of what we provide, contact me at Association Online and I'll show you that. It's really a simple form. When you look at it, the form itself, it just says what's your property address, who are you allowing to help you with the transaction, and then it allows them to list their HOA's names if they know them. When we're working on the transaction, we don't need that. We know what HOAs are on a given property, but that's basically what they fill out. It also asks for login information on a portal, a username and password. And it's kind of funny because we're asking them to fill in that information. It's not a required field on our form. But on the other hand, we're cautioning people about fraud and all these things. So it seems counterintuitive. So we will have sellers say, I don't feel comfortable entering my password here. And you know what? That's wise, I think. Actually, it's just the way the form is written. So if they skip that, we just do what we call a joint login. I think that it's awesome that they protect that information. But we've been doing these virtual calls with sellers since 2019, and we just set up a little meeting time, share our computer. They log in to their portal for us, and we don't know the login credentials, and they can sit there and watch while we put the document package together. So we really support that with sellers that have a healthy caution on, should I be passing out my username and password? Sometimes we'll tell them reset it, and after we use it, reset it, that kind of thing. But usually a little bit of FAQs at the front of the form and some good knowledge for you as agents to understand the form. We quickly can help sellers understand what's happening and get past that hurdle. It is it is a step though. It's a step to your process, but when it saves hundreds of dollars, we've usually people quit complaining when they understand they can save a lot of money. So
Yeah,
yeah,
it's a big deal.
yeah,
Now hopefully everybody starts requesting these at time of listing, but I do want to mention that as Jerie mentioned earlier, this is a commission approved form, the
yeah,
Seller Association authorization. So if you're not using Association Online's link, which again, I would encourage you to because it has those additional questions,
yeah,
but just know that form is available in CTM. I believe it's under 2020 approved documents and forms or something like that. So it's kind of in a, nondescript section of CTM, but it is available there. If you just find that's, easier for your people to sign.
yeah.
Let's see. Is there an expiration date on the information in the documents?
Oh, that's really good. That's a great question. Internally, when we deliver the documents, they come in a link where they're all separated out. You click on the link and then you can see the separation. And we leave the link live for 2 weeks. Um, because that's as long as we're comfortable to say, well, if something's changed, we want to change it. Now, what users do is they'll get the link, they look at the documents, they typically download them and save them. That's fine. I mean, your buyers are going to want to, save the information and know what they received. The point is, it was received at a point in time, and the data is changing constantly. And so anything that was released after that date is not in that disclosure, and the seller's not liable for it. They're liable to deliver the piece, the package at that one point in time. So our trigger point is a week and a half, 2 weeks, where we really wouldn't refresh a link for you without us internally checking it again.
Okay. What are your thoughts on requiring buyer confirmation, the buyer confirming receipt of docs?
Oh, that's a really interesting point. We have not written any code or software that would require the buyer to do that, but we do follow successful delivery through software. And we are adding the ability to see if the links were open. So we'll know. It's a little harder for us today, but we're adding software in the next couple of months that will include that, where we'll know if it was viewed in case that's needed for any legal support.
And then Jay is asking to please share contact information for joining the program. So, talk about the steps for becoming a member of the HOA Expert Program.
Yeah, that's a great question. We have a customer support group that is specifically for real estate agents, and the email address is support@associationonline.com. And that's probably the place to start there. You can also go to the website and look at HOA Sales Expert in the menu items. I think serve it on the top menu, it'll say services and resources. And when you click on that, you can see the HOA Sales Expert Program and you can click there. But by communicating with us either of those two ways, we can send you the information to answer your questions and explain all the benefits, and then step you through if you want to sign up, how to do that. And then the next step after you sign up is we will go through what I described as those service specifications. We want to learn from you, how do you like to do business? Are you planning to email us or make a phone call, or do you want to click on a button for these various steps in your transaction cycle? We learn that from you and we make notes in your file so we know how to work with you the most convenient way possible. And then we show you the tools and make sure that you're proficient in those. But our phone numbers you can text always. So everything works on a tablet and a phone as well as a PC. And most of our agents aren't interested in this, but just to let you know, with every account, if you set up an account, you also have a login portal, a regular piece of software where we're organizing your orders and keeping all your information organized and archived. And if you're interested even in knowing what your logins are, most of our agents are not. You guys are busy on the road and you just want to ping us and get information when you need it, and that's great. But your transaction coordinators may want a secure login and be able to look at all your properties and your order information, and manage it that way so we can serve you that way as well.
So, Jerry, okay, so would you say, kind of just summarizing, so a broker wants to sign up for the program. Again, there's no cost. It's just kind of that handshake agreement that you are going to work with Association Online for your association docs. So you reach out to support@associationonline.com or go on the website, get engaged with that program. Then, if I were a broker, I would probably, when I'm sitting down with my sellers and going through all the signing of listing contracts and whatnot, I would probably have that Association Online link right
Mm.
there, and I could just go through that with them and we can click on that. I could help explain the SAA to them so they can fill it out. And then I think it also will then ping them with a link to just pay by credit card online,
Yep.
right? So
Okay.
seller can pay the $65 per HOA kind of upfront. So they save a little bit. They can spend 65 upfront or they can spend 70 through closing.
Yep.
And then I think you said oftentimes the sellers are typically paying for that. Sometimes brokers will opt to pay for that cost for them upfront and then get reimbursed through closing. So that is another option that Jerry has mentioned to me before as well.
Right.
But then everything is kind of signed and ordered and ready to go as you were sitting there with your sellers, right?
Yep, that's exactly right. And so we'll show you, make sure you've got the link to the portal, and we'll show you the buyer page and the seller page. So there's one for each side of that transaction, and each one has a 5-minute video that tells that client of yours what should they expect and what are their responsibilities in their role in the transaction. And then, like you said, Jill, there's a link where you can click and go straight to the SAA. We can also show you how to grab a unique link. Some of our agents just want to put it in their welcome email, hey, congratulations on your listing. These are the things you need to do. Come here and start your HOA documents, and there's the link, and stage your home and do these other things. So that's when we learn how you do work. We'll show you how to do that if you want an introductory email. Yep.
That's wonderful. It's nice that you're willing to kind of customize that flow as much as
Yeah.
possible so it fits with what the brokers are already doing. So,
Right. Yeah.
okay. Okay, Shauna, thanks for putting that contact information in there. Let's see. Yep, we'll follow up with this recording, and then we're going to include all kinds of links and follow-up information as well, like I always do with these follow-up emails after our industry updates. Um, okay. I think that is about it. Let's see. I guess we'll just give it another couple seconds if you guys have any other last minute questions. But Jerie, is there anything else you would want to add or anything we didn't cover today that you think is important for brokers to know?
I guess I would say that the market is definitely changing. HOA information is becoming more and more important. Um, but we're just excited to be here and help you. And I want you to remember that we're here. So if you're not ready to jump into the program, but you realize in a week or two you've got a question about an HOA or you're running into a challenge, reach out to us. Let us help you with any wisdom we may have or any data we may have in our file. We have agents reaching out to us all the time with all kinds of questions, and we're happy to be a resource here for you and help you. And I want you to know that if you close with Chicago Title, we do all of their HOA work, and you will earn a $15 credit on one of those listing reports that I mentioned every time you close with them. And so we'll archive those credits for you. And when you're ready and need a report and want to use that, if you're a member of the program, we'll know if you're a member of the program and we'll monitor those closings and we'll make sure that we're keeping track of those credits for you and helping you use them. So,
Thank you. We appreciate that. Yeah, those reports are beautiful and just chock full of information, so clean and easy to read. They're amazing. There was another question that popped in from Jeff. Is there any legislation coming that you're aware of regarding HOAs?
that is a great question, and I'm updating. That reminds me, we offer also two CE classes, and I'm updating those, which include legislation. And as a part of our program, you get the CE classes at no charge, and by completing both, you can use the Certified HOA Specialist designation. And the first class that we do covers legislation. And one of the things that we're seeing is fiscal responsibility, possibly a bill that requires a reserve study. Right now, there's no reserve study required and there's no reserve funding required in our state. But there's a bill that's requiring a developer have a reserve study before they turn over to a board. The bill originally also required that the developer, I said builder, but I meant developer, that the developer funded the reserves a little bit before turning over to the neighborhood board. And I think that may have already been deleted out of the bill. But that's one that we're watching. We did have lawmakers indicate that they were going to possibly write a bill to require dispute resolution before attorneys were hired in HOA disputes. So between a homeowner and an HOA, the vision was that Dora would manage something like that. Haven't seen that bill presented yet, and we're late in the session at this point. So I'll be surprised if it comes up, but that's a really hot item that we hear talked about a lot year over year. So if we don't see it this year, maybe it'll come up next year. But again, trying to get away from lawsuits and require parties to negotiate and try to settle issues before hiring attorneys.
Fantastic.
Yeah.
Okay. Well, that's our hour. Thank you, Jerie, so much. As always, you are just incredibly knowledgeable when it comes to this world, and you're so willing to help and share. We just can't thank you enough for always being willing to provide education to the broker community. So, you are an absolute treasure to this industry, and
Oh,
we're so thankful for you and thankful for your time today. So,
oh,
thank you
thank you.
everybody for joining, and please think of Chicago Title when you're taking your next listing, and let's get those association documents dialed in up front, and we can't wait to see you at our closing tables.
Yes, thank you so much, Jill.
All right, thanks everybody. We'll see you next month.